Hello, lease matters. Kindly tomorrow.
Tomorrow this bench is not there, so it will come on Monday.
Monday. My lord, top of it because lease is hand on Monday, my lord. On second half.
Ready?
My lord.
My lord, I have mentioned yesterday, my lord, that the land acquisition matter, my lord.
Please give the memo.
Lord, I beg pardon to mention from the weekly list, my lord. Item number 226, my lord. It's a matter related to the examination of the judicial services for the year 2023 and 2024. Looking for evaluation of his mark, my lord, the notification has come up on.
Revaluation is not permissible. Revaluation is not.
Lord has directed the opposite party to seek instructions.
Sorry, there are several decisions. Revaluation is not permissible. So yes, call the matter.
Supplemental list, item number 1.
No privilege. Now the petitioner within the Union of India, my lord. And the petitioners have.
You come to the order dated 14/8/24. Place that order. See that order. Welcome you. Use it. 14/8/2024. Mic adjust करो. Settle पड़ा है तो सब.
Yes, my lord. Yes, my lord. Your lordship, in this order,
Please place the order
at paragraph 5.
Yes.
It appears that a criminal case was instituted against the opposite party by the CBI for accepting illegal gratification, and he faced trial in the court of the London Special Judge CBI Bhubaneswar on the self-same allegation. The CBI proceeding was initiated, memorandum of charges were served on the opposite party, and inquiry was conducted which resulted in passing the order of punishment. However, it is brought to our notice that the London Special Judge CBI Bhubaneswar has acquitted the opposite party of all as per the judgment and order dated 27/12/2012 in the criminal proceeding. London counsel for the petitioner submitted that he has instruction that there is no challenge to the aforesaid acquittal order. Yes, my lord. With this regard, my lord,
Please read the paragraph number.
London counsel for the petitioners seek time to address the court as to what would be the effect of the order on acquittal on the result of the disciplinary proceeding.
Yes, that is the.
Yes, my lord. This is query, my lord. But so far, I have received the instruction, my lord. The CBI has filed one CRLL against the order of the acquittal.
When?
My lord,
After our order was passed on 14/8/24.
no, before
Then
that.
what is the CRLLP number?
95. Yes, ma'am. 95 of 2013, madam. 13.
Okay. 95 of 2013 बात करो. Factors कौन देते हैं?
I have given the chapter sheet.
Factors add करेंगे. 95 of 2013. Special Judge Bhubaneswar. Okay. Okay. Yeah, also. On order path 180. Last order path 16, 11, 20.
As per
Last
only
year, the name of Sarthak Nine, that's also appealing. Brief indicator. So when the matter was filed in 2000, according to you, 2013.
Yes, sir.
So for the first time, was listed and some or in 2019. So we are pendency of the leave petition. Can that be a ground to stall the relief
No, ma'am.
which is entitled to?
That is not
Not yet admitted. That is not yet leave has not been granted. So it may so happen that leave may be refused.
Yes, ma'am.
No.
I cannot dispute that, ma'am.
No.
But the issue,
The fact remains that the acquittal order has been passed.
yes, sir.
Okay. Now
It's the admitted fact.
now the position of you say it is exactly the reason why we the prayer which has been made in this writ petition, you come to the prayer portion.
Yes, sir. Yes, ma'am. Prayer. In view of the above facts and circumstances, it is therefore humbly prayed that this honorable court may graciously be pleased to admit the writ petition, issue notice to the opposite party, call for the records from the forum below, and after hearing the parties, set us the impugned order dated 11/5/2023 passed by the London Cat Kotak bench in OA number 105/2015.
Please come to that order.
Yes, madam. 11/5. At page 370. Yes. Now, before placing this order, madam.
No, you place. We want to know.
The OA filed by the applicant was dismissed. Earlier we had order dated 30/7/2029, which order was challenged by the applicant before the Honorable High Court of Orissa in WPC number 28791 of 2019, and the Honorable High Court of Orissa had order dated 24/11/2022 passed the order of this tribunal dated 30/7/2018 for violation of Rule 105 of the CAT Rules of Practice 993, and without expressing any opinion on the merit, remitted the matter back to the tribunal for re-adjudication after giving the
Rule 105.
Yes, ma'am. That is, my lord, the London Tribunal reserved the judgment, madam. But that was not pronounced within the stipulated time as specified in Rule 105 of the
Kete period. 21 days. Okay. All right. Next. Proceed on. Next.
So that matter was remitted back as there is violation of Rule 105. The case of the applicant, accordingly, in compliance of the order of the Honorable High Court of Orissa, the OA was restored to file and had the London Council for both the parties afresh. The case of the applicant in brief is that while he was working as Senior Divisional Medical Officer, East Coast Railway, Andamunda, he was caught red-handed while taking illegal gratification of ₹1,000 for granting prescription to a railway employee by the CBI. Accordingly, a CBI case filed RC case number 3 of 2009 was registered in the court of the Special Judge CBI Bhubaneswar, which found the subject matter in TR number 33 of 2008 under section 13(1)D, read with section 13(2) and section 7 of the PC Act Consequently, charge sheet under Rule 9 of the Railway Servants Discipline and Appeal Rules 1968 was issued to him memorandum dated 9/1/2009 on the annexure A by 2 series.
You skip out. Come to paragraph 3. Page 373.
Yes, ma'am. The proceeding was culminated by imposition of penalty of withholding of 100%.
ଶେଷରୁ ଦେଖିକି ପଢନ୍ତୁ କାହିଁ ସେ ବସିଛି ସେଠି କଣଟା ଅସୁବିଧା ଜାଣିପାରୁନି ସିଏ ପରା ଆପଣଙ୍କୁ ସାହାଯ୍ୟ କରିବାକୁ ଜଣକୁ ବସା ହେଇଛି ସେଇଥିପାଇଁ ସେ ଆପଣଙ୍କୁ ଜଣେଇବ page 373 was
The proceeding was culminated by imposition of penalty of withholding of 100% of the monthly pension on permanent basis and forfeiting the entire gratuity admissible to the applicant by order dated 21/11/2012. In the CBI case, the applicant was acquitted honorably by order dated 27/12/2012. Thereafter, the applicant filed application dated 18/2/2013, enclosing thereto copy of the judgment of the CBI to review the order passed by the disciplinary authority, but the same was rejected by the order dated 19/3/2014, communicated to the applicant by letter dated 21/3/2014 under annexure A by 10. Being aggrieved, the applicant has filed.
Just take pause for a moment. That means the 21/11/2012 the
rejection order was communicated to the applicant.
Upon proceeding was culminated by imposition of by order dated so disciplinary proceeding that was
19/3/2012 rejected. Review filed by the madam, may I place it again? The proceeding was culminated by imposition of penalty of the withholding of 100% of the monthly pension on permanent basis and forfeiting the entire gratuity admissible to the applicant by the order dated 21/11/2012.
After the judgment in the CBI case.
Yes, ma'am.
By the trial court, right?
Yes.
Okay, then.
In the CBI case, the applicant was acquitted honorably by the order dated 27/12/2012. Okay. Thereafter, the applicant filed application dated 18/2/2013, enclosing thereto copy of the judgment of the CBI court to review the order passed by the disciplinary authority, but the same was rejected by the order dated 19/3/2014. Review was rejected. And communicated to the applicant by letter dated 21/3/2010. Being aggrieved, the applicant has filed present way to quash the order of the disciplinary authority dated 21/11/2012 and the order dated 19/3/2014 of the reviewing authority.
Yes.
Thereafter, para 4, respondents filed their counter contesting the case of the applicant inter alia, stating that since the degree of proof in the departmental proceeding and the criminal case is different from each other, mere exoneration by the court acquit the outcome on the disciplinary proceeding. It is contended that the applicant has been imposed punishment consequent upon an inquiry conducted against him by following the due procedure of rules, since even though a person is acquitted from the criminal charge, punishment imposed by the disciplinary departmental authority based on the disciplinary proceeding cannot be taken out. The applicant has challenged the order of punishment and the outcome of the proceeding only on technical some procedural irregularity. He has failed to point out in which way he has been prejudiced. According to them, there was no violation of any statutory rules and principle of natural justice. Having been fully complied with, there is hardly any scope for this tribunal to interfere in the order of punishment which was imposed by the disciplinary authority, taking into consideration all aspects of the matter. Further, placing reliance on the decision of the Honorable Supreme Court in State Bank of Patiwala.
Reference कौन से केस रो? State Bank of Patiala
Yes, sir.
versus
Versus
S.K. Sharma.
S.K.
The reference for
And I have given memo of citation.
ठीक है
Contribution of
reference
that.
the reference টা কোন আছে দেখি
And
S.K. Sharma
2023 5 SEC.
2023 5
Sorry, man. 1996 3 SEC 36. 1996 3 SEC 364.
364.
And I am relying para 30.
Para
34 man.
Para 34. Let us go and then we'll read that. सीधा पढ़े सुनसे judgment की S.K. Sharma judgment. Para 34.
And internal page 16. We may summarize the principles emerging from the above discussion. These are by no means intended to be exhaustive and are evolved keeping in view the context of disciplinary inquiries and orders of punishment imposed by an employer upon the employee. First, an order imposing a punishment on an employee consequent upon a disciplinary or departmental inquiry in violation of the rules, regulations, statutory provisions governing such inquiries should not be set aside automatically. The court or tribunal should inquire whether a provision violated is of substantive nature of B, whether it is procedural in character. Second, the substantive provision has normally to be with, as explained herein before, and the theory of substantial compliance or the test of prejudice would not be applicable in such a case. In the case of violation of a procedural provision, the position is this. Procedural provisions are generally meant for affording a reasonable and adequate opportunity to the delinquent officer public employee. They are generally speaking conceived in his interest. Violation of any and every procedural provision cannot be said to automatically vitiate the inquiry held or order passed, except cases falling under no notice, no opportunity, and no hearing categories. The complaint of violation uh, of procedural provision should be examined from the point of view of prejudice. That is, whether such violation has prejudiced the delinquent officer or employee in defending himself properly and effectively. If it is found that he has been so prejudiced, appropriate orders have to be made to repair and remedy the prejudice, including at the inquiry and or the order of punishment. If no prejudice in established is established to have resulted therefrom, it is obvious no interference is called for. In this connection, it may be remembered that there may be certain procedural provisions which are of a fundamental character whose violation is by itself proof of prejudice. The court may not insist on proof of prejudice in such cases. As explained in the body of the judgment, take a case where there is a provision expressly providing that after the evidence of the employer or government is over, the employee shall be given an opportunity to lead defense in his evidence, and in a given case, the inquiry officer doesn't give that opportunity in spite of the delinquent officer or employee asking for it. The prejudice is self-evident. No proof of prejudice as such need to be called for in such a case. To report is one of the prejudice, that is, whether the person has received a fair hearing considering all things. Now, this very aspect can also be looked at from the point of view of directory and mandatory provisions, if one is so inclined. The principle stated under 4 herein below is only another way for looking at the same aspect as it dealt with herein and not a different or distinct principle. Fourth, A. In case of a procedural provision which is not a mandatory character, the complaint of violation has to be examined from the point of substantial compliance. Be that as it may, the order passed in violation of such provision can be set aside only where such violation has occasioned prejudice to the delinquent employee. B. In case of violation of a procedural provision which is a mandatory character, it has to be ascertained whether the provision is conceived in the interest of the person proceeded against or in public interest. If it is found to be the former, then it must be seen whether the delinquent officer has waived the said requirement either expressly or by his conduct. If he is found to have waived it, then the order of punishment cannot be set aside on the ground of said violation. If, on the other hand, it is found that the delinquent officer stroke employee has not it or that provision could not be waived by him, then the court or tribunal should make appropriate directions, include the settling aside of the order of punishment, keeping in mind the approach adopted by the constitution bench in B. Kanikar, the ultimate test is always the same, that is test of prejudice or the test of fair hearing, as it may be called. Fifth, where the inquiry is not governed by any rules, regulations, statutory provisions, and only obligations is to be observed the principle of natural justice, this will not be applicable.
You placed reliance on this decision.
This is the guideline. Wherein
here is a case where he was found guilty in the proceeding, punishment was imposed. Thereafter, he was acquitted by the London Trial Court. Now, the question is that he filed a review petition that since I have been acquitted, this punishment which has been imposed on me may be set aside. That is so the question is, what would be the effect of an acquittal order passed by a criminal court on the already concluded departmental proceeding, whether that can be a ground for review of that order passed. So where this point has been answered in this one, have you placed this decision?
I will place all these things on. Before going there,
decision point out seya.
ସେଥିରେ ଆଉ ଗୋଟେ ପଏଣ୍ଟ ଅଛି, ସେଥିରେ ହେଇଛି କଣ ନା ଯେତେବେଳେ ତାକୁ ଦେଲେ when the punishment
are not concerned with that point.
That is relevant matter. When the punishment order was communicated to the petitioner, at that time the opinion of the UPSC was called for and that was also given. And his point is that when the
a decision say जो point कथा वर्तमान समय रेज करूचंदी जो जोथिपाई केस अर्जन हेइतला आजी को ये व्हाट वुड फ्यूचर
that is latter part matter. Before that there is another point of law involved.
Last time हम बुझिबा चेष्टा करंतु ऑर्डर टा जो लास्ट ऑर्डर टा पास हेइची सेही ताकू आंसर करिवा को ए केस रे किसी डिसाइड हेइची कि ए जो ये रे जो then it
the procedure one of the ground they have taken that there is procedural.
Proceed with that. You are placing that judgment. Come to that. Let us see. You have to
point manner.
जोड़ा पढ़ुथिले मो judgment of the tribunal.
Yes ma'am.
Who जाय पढ़ुथिले आपण?
Bank of Patiala versus S.K.Sahoo Hon'Ble. It has stated that even if there was procedure, but this is the point of law.
Okay.
If there was procedural violation in course of inquiry, in absence of judicial review is not warranted. It has been submitted that in course of departmental proceeding, the applicant had never raised any such complaint before either before the IO or the disciplinary authority regarding violation of any rules or procedure. According to the respondents, the special judge CBI has gone to technicalities in the matter and arrived at that this preparatory action of the prosecution from the beginning was not in consonance with the law. They have submitted that while dealing with the departmental proceeding, the IO analyzed the evidence and documents available on record and arrived at a clear finding that the applicant is guilty of allegations leveled against him. Thus, this way being devoid of any merit and is liable to be dismissed.
Yeah.
Next one, point 5. In course of hearing, counsel for the applicant has submitted that imposition of punishment of withholding 100% monthly pension and forfeiture of gratuity has a direct nexus to right to life enshrined under Article 21 of the Constitution of India. Therefore, the Honorable Apex Court, in more than one occasion, cautioned that imposition of such punishment in a casual and cavalier manner should be avoided. But in the instant case, the applicant has been deprived to right of life in a manner contrary to the rules and law. The allegation in the memorandum of charge was that the applicant, while working as senior DMO, BNDM, committed grave misconduct on 24/2/2008 in as much as he demanded and accepted an illegal gratification of rupees 1,000 from Sri Uday Singh Sawayan, son of Sri Ghasiram Sawayan, who was working as Safaiwala in Southeastern Railway Hospital, Adityapur, for his treatment violating the provisions contained in para 602 and 633 of the Indian Railway Medical Manual, Volume 1, 3rd edition 2000, which inter alia states that medical attendance and treatment will be available free of charge to all railway employees, their families, members, and dependent relatives as defined under past rules, irrespective of whether the employees are in Group A, B, C, or D, whether they are permanent or temporary, and was caught red-handed by CBI Bhubaneswar while demanding and accepting illegal gratification, which was exactly the subject matter of challenge before the CBI court in tier number 33 of 2008, wherein the special judge CBI Bhubaneswar acquitting the petitioner honorably by the order dated 22/12/2012, whereas the applicant was imposed with the punishment without providing the essential ingredients of the allegation made in the charge sheet, that is, demand and acceptance of illegal gratification of rupees 1,000. Yet he has been punished in a slipshod manner, for which, by making application, the applicant exercised his right to review the order of punishment. It has been contended that the IO came to the conclusion that the GC note were seized from the pocket of the applicant. The charge is held to be proved, which is against the law and the order of the London Special Judge. On 1/2/2011, the applicant submitted his defense to the report of the IO, but the General Manager, Railway, without any competent jurisdiction and authority, examined the report of the IO and recommended for imposition of punishment, holding that the charge was robbed. It has been submitted that the matter was referred to UPSC for advice. The UPSC, by letter dated 19/3/2012, solely based on the complaint of Sri Singh Sawan, dated 23/2/2008, opined imposition of punishment of withholding of 100% of monthly pension and forfeiture of entire gratuity. According to the applicant, based on the recommendation of UPSC and the GM, the disciplinary authority has proved through, though IO did not hold the same, and imposed such punishment, which was communicated to the applicant by letter dated 12/12/2012. It has been submitted that proof of demand and acceptance of illegal gratification has to be established to the hilt of for holding one guilty of receipt of illegal bribe, when the complaint and witness had not supported the prosecution case with regard to demand of bribe, and the applicant more mere recovery of the tainted money diverse from the circumstances under which it is paid is insufficient to hold charge as proved by the IO. The basis on which the IO held the charge proved is also not one of the allegations in the charge sheet. In this regard, Law and Counsel for the applicant has placed reliance in the case of Ramanlal Moonlal
Andhya.
Andhya
State of
versus State of Bombay, year 1960, Supreme Court 1961, and Surimal versus State, year 1979, Supreme Court 1. Further, Law and Counsel for the applicant, in support of his submission, that on presumption that the money was accepted as a motive cannot be raised when demand has not been proved in the law of the land. Venkatrao Subbarao versus State, CRT IG 207, page 70, 754. Thus, according to the Law and Counsel for the applicant, holding the charge as proved by the IO was on presumption and based on which imposition of punishment in holding acceptance of gratification by the applicant without any such finding by the IO in its report is bad in the law. It has been submitted that complainant himself denied any such allegation before the competent court of law, and on that basis, the applicant was acquitted in the criminal case. Therefore, the imposition of punishment ought to have been removed by the competent authority when the allegation of demand and acceptance of illegal gratification was not proved. The counsel for the applicant has also placed reliance on the decision of the Honorable Apex Court in the case of Pannalal Damodar Rathi versus State of Maharashtra, 1979, Volume 4 SEC 5 to 6, to state that when there is no testimony of the complainant regarding demand and acceptance of bribe, it is to be accepted that the version of the complainant is not corroborated and version of the complainant cannot be relied upon. In the instant case, neither the general manager nor the disciplinary authority has whispered who is the departmental witness who vouchsafed regarding authenticity of statement of informant. Thus, according to the applicant, the imposition of punishment is bad in the law. Also, it has been submitted that mere recovery of tainted money, the circumstances under which it is paid, is not sufficient to convict the accused when the substantive evidence in the case is not reliable. In this connection, he has relied on the decision of the Honorable Apex Court in case of Surajmal versus State, Delhi Administration, 1979, 4 SEC 7 to 5. Next contention of the Law and Counsel for the applicant is that gross injustice was caused to the applicant in the decision-making process of the matter. The applicant was imposed with the punishment by accepting the advice of the UPSC in toto, but without supplying the copy of the same prior to the imposition of punishment, by way of giving the applicant an opportunity to put forth his grievance. He submitted that non-furnishing of second stage of advice when such advice resulted in infliction of penalty violates the principle of natural justice and prejudice to the applicant, and therefore the order of punishment is liable to be quashed. In this regard, the counsel for the applicant has placed reliance in the case of State Bank of India and others versus D.C. Agrawal and another, 1993 Supreme Court L&S 109, and Union of India and others versus S.K. Kapoor, civil appeal number 531 of 2006, dated 16/3/2011, Oriental Bank of Commerce and others versus S.K.Sahoo Hon'Ble and another, 2014, 2 SEC L&S 1 to 5, and S.N. Narula versus Union of India and others, 2011, 4 SEC 591. Law and Counsel for the applicant has also relied on the decision dated 15/3/2018 of this bench of the tribunal in way number 816 by 2011 of the Honorable Apex Court in the case of GM Tank versus State of Gujarat, 2006, 5 SEC 446, and K. Venkateswaralu versus State of Andhra Pradesh, 2012, 2 SEC L&S 484. To substantiate that applicant having been acquitted in criminal case on self-same allegation, the punishment is liable to be passed. On the other hand, when counsel appearing for the respondent to strengthen the stand taken in the counter has submitted that in a cutting of cases, the Honorable Apex Court has laid down that even after conclusion of criminal proceeding, there is no bar for initiation of proceeding. The prosecution in the criminal case has failed to establish the charge for that the applicant was exonerated by the criminal court on the benefit of doubt, but in the departmental proceeding, the DA disciplinary authority prima facie was satisfied that the documents, evidence available and collected in course of the proceeding are sufficient to arrive at a conclusion holding that the applicant was guilty of the charge of accepting bribe. It has been submitted that although the applicant alleged some discrepancies in proceeding, but the same cannot affect the proceeding as the credible evidence are available to come to a definite conclusion that the charge is proved. Further, the power of judicial review cannot be exercised to scrutinize the evidence for the purpose of coming to a different conclusion. Further, the allegation of the applicant that he was not afforded a proper opportunity to defend his case properly is baseless, as the witness cited by the applicant were either interested or related to him, and others had no case. Relying on the decision of the Honorable Supreme Court in State Bank of Patiala versus S.K.Sahoo, what I have already.
Yes.
It has been stated that even if there are procedural violations in course of inquiry, in absence of prejudice, judicial review is not warranted. Accordingly, submit that this OA is being devoid of merit is liable to be dismissed. Ninth, we have considered the rival submissions of the respective parties. It is seen that allegation in the CBI case was for demand and illegal gratification, which was also subject matter of the disciplinary proceeding. In the disciplinary proceeding, the applicant was imposed with the punishment. In the CBI case, the applicant was exonerated from the charges on the very fact that the FIR, which was foundation of the prosecution, was found to be weak. The relevant portion of the order,
Paragraph 10%.
in the GM Tang versus State of Gujarat, 2006, 5 SEC 446, the Honorable Apex Court have interfered in the imposition of punishment in the disciplinary proceeding since the applicant herein was a criminal case. The allegation in both the cases were being same. In the case of State Bank of India and others versus DC Agrawal and another 1993 Supreme Court L&S 109, Honorable Apex Court observed that non-supply of CVC recommendation, which was prepared behind back the respondent without his participation, and one does not know what material which was only sent to the disciplinary authority but was examined and relied, was certainly violative of procedural safeguard and contrary to fair and just inquiry. Taking action against the employee on confidential document which is the foundation of order exhibits complete misapprehension about the procedure that is required to be followed by the disciplinary authority. Well, may I pause here 1 minute? In this case, the report was sent to the disciplinary authority, but in the present instant case, we also supply a copy of the UPSC advice to the delinquent officer Maldeep.
That he denied.
No, he received one.
No, he has denied that.
He has denied that.
He has denied.
He has not been supplied with a copy of the UPC advice. That is not.
He has supplied with. That is.
He might have supplied, but he has denied in that.
That is the finding that before imposing that major punishment, if you are backing with the report of the authority, whether at that stage it is required to be supplied to the delinquent or not. And if it is not supplied, what would be its effect? That is to be decided also.
So that is what the question arose, whether by not supplying that particular advice of the UPC, he was prejudiced or not. That was the question. In view of the judgment.
On this point, my lord, already several petitions
No.
are.
Finish it up and then.
Yes, ma'am. Maybe that the district authority has recorded its own finding, and it may be coincidental that the reasoning and basing of the returning
Basis of reasoning.
finding of the reasoning and the basis of returning the finding of guilty are same as in CBC report, but it being a material obtained behind back of the respondent without his knowledge or supplying of the copy to him,
Yes.
the High Court is, in our opinion, commit an error in quashing the order. No supply of the vigilance report was one of the grounds taken in appeal, but there was so because the respondent prior to service of the order passed by the disciplinary authority did not have occasion to know that CBC has submitted some report against him. The submission of the learned additional solicitor general, the CBC recommendation are confidential copy of which could not be supplied cannot be accepted. Recommendation of vigilance prior to initiation of proceedings, that CBC recommendation which was basis of the order passed by the disciplinary authority. Further, in the case of Union of India and others versus S.K.Sahoo, Civil Appeal number 5341 of 2006, dated 16/3/2011, the Honorable Supreme Court opined that although Article 320
3C
plus 3 subclause C is not mandatory, if the authorities do consult the Union Public Service Commission and rely on the report for taking disciplinary action, then principle of natural justice required that copy of the report must be supplied in advance to the employee concerned, so that he may have an opportunity of rebuttal. There may be a case where the report of the Union Public Service Commission is not relied upon by the disciplinary authority, and in that case, it is certainly not necessary to supply a copy of the same to the concerned employee. However, if it is relied upon, then a copy of the civil appeal number such and such same must be supplied in advance to the concerned employee. Otherwise, there will be a violation of the principle of natural justice. In the case of Oriental Bank of Commerce and other versus Siocon and another, 2014 2 SCC L&S 125, it has been held that by the Honorable Appeals Court that after receipt of CBC report, major penalty imposed. CBC report not furnished to the delinquent. Any material which goes into the employee cannot be denied to him. Non-supply of UPSC advice before imposition of penalty was held to violate the principle of natural justice. In the case of S.N. Narol, instant case, undisputedly the advice tendered by UPSC was duly accepted by the
Wait. Was duly accepted by the disciplinary authority.
duly accepted by the disciplinary authority and imposed the order of punishment of 100% cut off pension and forfeiture of gratuity, and copy of the said UPSC advice was supplied to the applicant along with the order of the punishment, and therefore we find sufficient force on the submission of learned counsel for the applicant sought by the applicant, so the statement of complainant, etc., is also found to be contrary to law. It is seen from the record that the applicant has prayed before the IO to allow some witnesses on his behalf, out of which some of them are doctors, staff nurse of the dispensary, hospital, and another government employee, besides some of his family members. The IO rejected the prayer of the applicant, citing the grounds which, in the peculiar facts of circumstance of this case, don't appeal to the conscience. Thus, the stand of the applicant that he was highly prejudiced for such action of the IO is found to be justified and is held to be in violation of the principle of natural justice. The compliance of natural justice in domestic or disciplinary inquiry is necessary, has long been established. It is settled law that even there are no specific statutory rule requiring observance of natural justice, the compliance of natural justice is necessary. Certain ingredients have been held to be constituting integral part of an inquiry by Chamoli District Cooperative Bank Limited and another versus Raghunath Singh, Rana and others. Civil Appeal number 2265 of 2011. Further, it is settled law that natural justice generally requires that persons liable to be directly affected by proposed administrative acts, decisions, or proceedings be given adequate notice of that is
Of what is proposed.
adequate notice of what is proposed, so that they may be in position to make representation on their own behalf, or B, or to appear at a hearing or inquiry, if one is held, and C, effectively to prepare their own case and to answer the case, if any, they had to meet. Even when a state agency acts administratively, rule of natural justice would apply by K.I. Shepherd and others, etc., versus Union of India and others, 1988 AR 686. The decision made conclusively establishes that the punishment imposed on the applicant was in violation of principle of natural justice and law discussed above. Hence, impugned orders dated 21/11/2012 and 19/3/2014 are hereby quashed. In ordinary course, the matter would have remitted back to the respondents for consideration after complying with principle of natural justice, but taking into consideration the fact that this matter is going on for last 14 years and that at the age of the applicant 71, we are refrained from doing so, and in view of the quashing of the impugned order of punishment, the respondents are directed to release pensionary dues to the applicant within a period of 60 days from the date of receipt of the copy of this order. In result, the way stands allowed. There shall be no cost, just to cost.
Yes.
Now, this order, before passing this order, on self-same evidence, now this tribunal also dismissed the on first instance.
That was set aside by this.
No, that was set aside not on merit matter. That was set aside on the ground of the pronouncement of judgment, delaying pronouncement of judgment.
Once a decision
This point has already been dealt with in that judgment.
So,
This point particularly has dealt with that judgment.
Mr. Counsel, just
Yes, sir.
when this court at the first instance set aside the order of the tribunal, did you approve the Honorable Supreme Court?
No, my lord. Here,
Why are you saying that in the party?
why my you are not approved?
Why you are not approved? It is up to you. The fact remains that the first judgment was set aside. The matter was sent back for rehearing, and rehearing after rehearing, this order was passed.
Yes, sir. That
At the first instance, Mr. X has taken a view, and how Mr. Y will
same bench,
whoever may be.
No,
That order is
this honorable court remitted the matter not on merit matter.
the merit or not merit, that order has been set aside. It has not been challenged. So we will not look.
Can we look into it?
Can we
look into it?
The order has been
My humble submission before you is that if the self-same evidence, the tribunal has dismissed on discussing this ground also, the supply of UPSC also, and which was not the matter before the case.
That is your ground. That is your ground.
What is not the case of the applicant? He never pleaded in the.
That is one of your ground.
Yes, ma'am. Wonderful. And so far as natural justice is concerned,
it may so that earlier the matter was not properly placed by the Land and Council. All the citations was not brought to the notice. That is why the order was passed. The matter was heard perfectly in the second instance. That is how this order was passed. That cannot.
if the London tribunal has discussed with
Or to say that the earlier order is just a replica of this subsequent one, it is a replica, or further discussions are there. Some deviation in the all that is there or not? But the earlier order is complete
just reverse matter. That is
then complete.
what happened, matter. The natural justice has been complied. I will show matter. He has totally participated in the proceeding, he has cross-examined, and the cross-examination matters are there clearly on the record, my lord. It is established that he has taken the bribe. I will show
You see, the scope of judicial review
yes, ma'am.
is very limited. So you show us that how the
Yes,
decision
sir.
which has been arrived at by the subsequent judgment which has been imposed in this case is illegal.
Yes, ma'am. Well, I have cited.
Don't praise that earlier she was passed, that
Yeah.
was set aside. The fact
This,
remains
this,
are not
this
correct.
honorable court,
Okay, that.
this
Yes.
honorable court, my lord, Justice Das is also a party to the judgment. Kalakar Chakra versus Orissa Gramya Bank and other 2022, Volume 3 ILR, Cutoff 670. Well, kindly have a glance to para 17, 18, and 20. First, internal page 673, madam.
No, what is the factual aspect of that case? Whether same thing has happened?
Well, I will place the proposition.
No, proposition का what a factual context में से proposition का acceptable हो.
Yes, ma'am.
देखिए factual scenario अलगा ହେଇଗଲେ ratio to change ହେଇଯିବ.
Yes, ma'am.
ତେଣୁ ସେ କେସରେ କଣ ଏଇଆ ହେଇଥିଲା ଆପଣ ଯୋଉ ପ୍ରିନ୍ସିପଲ ଟା କହୁଛନ୍ତି
on the procedural irregularity, so also natural justice, ma'am. The above paragraph, the above submission have been considered the scope of interference by the High Court under Article 226 of the Constitution of India in disciplinary inquiries is fairly well settled in Government of Andhra Pradesh versus Muhammad Nasrullah Khan, 2006 Supreme Court 1214. It was observed at under. By now, it is well established principle of law that the High Court exercising power of judicial review under Article 226 of the Constitution doesn't act as an appellate authority. Its jurisdiction is
पूरा applicable जो फाइल करछंती ए प्रिंसिपल टा पूरा applicable जोटा my esteemed brother and honorable then Chief Justice has relied upon. So we are not the appellate authority. We are not to act as an appellate authority. Our jurisdiction is circumscribed, confined, and to correct errors of law. So what is the correct the errors of law?
Procedural error. If any resulting in manifest miscarriage of justice or violation of principle of natural justice, judicial review is not akin to adjudication on merit by reappreciating the evidence as an appellate authority. Therefore, para 18. Further, the High Court is not expected to act as an appellate court sitting in appeal over factual finding in a disciplinary inquiry. All that the High Court had to examine whether there were any error of law or law resulting in manifest miscarriage of justice or violation of principle of natural justice. In the present case, it is a fact that the appellate never himself faced any criminal charges. In other words, he was not sent up for trial at all. Therefore, I am coming. Therefore, as far as the appellant was concerned, the mere fact that arising out of the same case, the criminal case was instituted against 3 other persons stated to be involved in misconduct were acquitted by the trial court would not ipso facto mean that the appellant also should be exonerated in the disciplinary procedure.
Mr. Counsel,
he was there, my lord. He was arraigned.
He was arraigned, but the other persons faced trial.
Yes, ma'am. They were acquitted.
Yes. This opposite party was faced trial and acquitted.
Yes, ma'am. Therefore, my lord, paragraph 24. To legal position, an acquittal in a criminal case involving certain other persons in relation to the same incident will not result in an automatic exoneration and disciplinary proceeding of another employee who never faced the criminal trial.
Yes. Actually, we have to see, sir, in service jurisprudence, lot many cases are there which might appear to be similar. The principles are same, but facts are different.
Yes, sir.
Your principle we don't deny. We do accept the principles.
In second case, State of Rajasthan and others versus Hem Singh, 2023 5 ACC, 569, paragraph 26, ma'am.
Wait. Para 26.
Yes.
जोड़ा पूरा ଯେତିକି ଡିସିସନ ରିଲାଏ କରିଛନ୍ତି ତାଠୁ ଏପଟୁ ଏମୁଣ୍ଡୁ ସେମୁଣ୍ଡୁ ଯାଏ ଗୋଟେ ସିରିଏଲ ନମ୍ବର ଦେଇଥାନ୍ତେ ତାହେଲେ ସୁବିଧା ହେଇଥାନ୍ତା।
Pagination
ରେଜିନେସନ କରିଦେଇଥିଲେ ଭଲ ହେଇଥାନ୍ତା। କୋଉ ପେଜରେ ଅଛି ସେଟା? ତଳେ ପେଜ ନମ୍ବର ଦିଆଯାଇଛି କୋଉ ପେଜରେ ଅଛି?
Page number 16.
16-17.
Evidence on
Wait. Page 16 ରେ
Yes,
କୋଉ
sir.
paragraph ପଢିବାକୁ ପଡିବ?
Para 26.
26 କଣ?
His evidence highlights that the police investigating Bhanwar Singh's death added the offense under section 302 of IPC based on evidence of Jyot Singh P.W. He also acknowledged that Jyot Singh changed his stance
from
before the court, however, did not offer any justification for it. This is based on the following evidence. On the basis of preliminary inquiry, my sentence
ପଢୁଛନ୍ତି ନା
yes, ma'am.
କ୍ଲାସିଟମ ଦେଖି
it starts my page 19 upper part judicial review over disciplinary matters 18 ରୁ heading ଟା ଅଛି ତା ଉପରେ we have to now assess
କୋଉଠି ପଢୁଛନ୍ତି?
page 19 upper part we have to now assess as to whether in arriving at its finding the High Court has transgressed the limitations on its power of judicial review. In Manishankar vs. Union of India 2008 3 SEC 484, a two-judge bench of this court had to assess whether the Central District Tribunal has exceeded its power of judicial review by overturning the finding of departmental inquiry by reappreciating the evidence. In the regard, the scope of judicial review of the court held as thus. The departmental proceeding is a quasi-judicial one. Although the provision of the Evidence Act are not applicable in the said proceeding, principle of natural justice are required to be complied with. The court exercising power of judicial review are entitled to consider as while inferring commission of misconduct on the part of the delinquent officer, relevant piece of evidence has been taken into consideration and irrelevant facts have been excluded therefrom. Interference on facts must be based on evidence which meet the requirement of legal principles. The tribunal was thus entitled to arrive at its own conclusion on the premise that the evidence adduced by the department, even if it is taken on its face value to be correct in its entirety, meet the requirement of burden of proof, namely preponderance of probability. If on such evidence the test of the doctrine of proportionality has not been satisfied, the tribunal was within the domain to interference.
Yes, that
we must also this thereafter
doctrine of proportionality.
If you find out any decision, just be clear.
Effect of acquittal.
We are କହିଲି ତ ଶୁଣିବାକୁ ଧୈର୍ଯ୍ୟ ନାହିଁ। Have you find out ନାହିଁ କହୁଛନ୍ତି? ଶୁଣିବାକୁ ଧୈର୍ଯ୍ୟ ନାହିଁ ଆପଣଙ୍କର? ନାହିଁ କହୁଛନ୍ତି?
ନାହିଁ ମୁଁ କହିଲି
just listen to me. Have you find out a single decision in which after the person facing the disciplinary proceeding where it has been held that the charges have been proved, punishment has been imposed, right? Thereafter, the verdict in the criminal case came and he was acquitted. Same allegations. Then he filed a review petition before the authority that in view of the acquittal order passed by the trial court, now you reverse your decision. So if such a petition would be filed, what would be the effect? So in that light, any adjudicating any decision of the Honorable Supreme Court that in such a situation, what would happen?
Yes, that one is to find out.
He has already been found, it has been held, punishment imposed. Thereafter, the result came in the trial court.
Yes.
So, what would be the effect?
ଏଇଥିରେ ବି ଅଛି ଗୋଟେ ପାରାଗ୍ରାଫ ମୁଁ
Document put as
next page my 20.
24, you see, 24. Why don't you come to the relevant paragraph?
20 ରେ ଅଛି the effect of an acquittal.
That is what
J.
that
J.
is what is, and the relevant paragraph is that is honorable acquittal. That you have to come, no?
Yes.
You harp on those which are important for you.
Yes.
Going here and there will.
In
As the court has said.
In the present case, we have an acquittal in a criminal trial on a charge of murder. The judgment of the Sessions Court is a reflection of the vagaries of the administration of criminal justice. The judgment contained a litany of hostile witnesses and other star witnesses resulting from his statement. Our precedents indicate that acquittal in a criminal trial in such circumstances does not conclude a disciplinary inquiry. In Southern Railway Officers Association of India 2009 9 SCC 24, this court held acquittal in a criminal case by itself cannot be a ground for interfering with an order of punishment imposed by the disciplinary authority. The High Court did not say that the said fact had not been taken into consideration. The revisional authority did so. It is now a well-settled principle of law that the order of dismissal can be passed even if the delinquent official has been acquitted of the criminal charge. Thereafter, 21 page. Acquitted by a criminal court, it will be allowed. Para 24, page 20. In the meaning of expression honorable acquittal came up for consideration before this court in RBI and versus Bhopal Singh Panchal 1994 1 SCC 541, 1994 SCC L&S 554, 1994 26 ATC 619. In that case, this court has considered the impact of regulation 46 dealing with honorable acquittal by a criminal court on the disciplinary proceedings. In that context, this court held that the mere acquittal does not entitle an employee to reinstate in service. The acquittal, it was held, has to be honorable. The expression honorable acquittal, acquitted of blame, fully exonerated, are unknown to the Code of Criminal Procedure or the Penal Code, which are coined by judicial pronouncements. It is difficult to define precisely what is meant by the expression honorably acquitted. When the accused is acquitted after full consideration of the prosecution evidence and that the prosecution has miserably failed to prove the charges leveled against the accused, it can possibly be said that the accused was honorably acquitted.
The important part is para 26.
Yes, ma'am. I am coming. As we have 26. As we have already indicated, in absence of any provision in the service rules for reinstatement, if an employee is honorably acquitted by a criminal court, no right is conferred on the employee to claim any benefit, including reinstatement. The reason is that the standard of proof required for holding a person guilty by a criminal court and the inquiry conducted by way of disciplinary proceeding is entirely different. In a criminal case, and this is important matter, in a criminal case, the onus of establishing the guilty of the accused is on the prosecution, and if it fails to establish the guilty beyond reasonable doubt, the accused is assumed to be innocent. It is settled law that the strict burden of proof required to establish guilty in a criminal court is not required in a disciplinary proceeding, and preponderance of probability is sufficient. There may be cases where a person is acquitted for technical reasons or the prosecution of other witnesses, since few of the other witnesses turned hostile, etc. In the case on hand, the prosecution did not take steps to examine many of the crucial witnesses on the ground that the complainant and his wife turned hostile. The court, therefore, acquitted the accused, given the benefit of doubt. We are not prepared to say that in the instant case, the respondent was only acquitted by the criminal court, and even if it is so, he is not entitled to claim statement since Tamil Nadu service rules don't provide so. Thereafter, my lord.
So these are the paragraphs quoted from that case
Yes.
Samuthi Rao, that is 2013 one SCC 598. Three paragraphs have been quoted from that judgment.
Yes.
Okay, now you
Yes.
come to the paragraph number 35 of this judgment which you are placing.
Yes. In the present case, the respondent was acquitted of the charge of murder. The circumstances in which the trial led to an acquittal have been illustrated in the detail above. The verdict of criminal trial did not conclude the disciplinary inquiry. The disciplinary inquiry was not governed by proof beyond reasonable doubt or by rules of evidence which govern the criminal trial. True, even on the more relaxed standard which governs the disciplinary inquiry, evidence of the involvement of the respondent in a conspiracy involving the death of Bhanwar Singh would be difficult to prove. But there are, as uh, we have seen earlier, circumstances emerging from the record of the disciplinary proceeding which bring legitimacy to the contention of the state that to reinstate such an employee back in service will erode the credibility of and public confidence in the image of the police force. Therefore, 136. Therefore, the direction of the division bench for reinstatement is set aside in exercise of the jurisdiction under Article 442 of the Constitution. We direct the cessation from service will notionally take place on the respondent completing minimum qualifying service. The direction of the High Court that the respondent shall not be entitled to back wages is upheld. The retired dues of the respondent will be computed and released on this basis within a period of 3 months. The appeal is allowed. Thereafter, I have already placed 41.
S.K. Sharma you have placed.
Patiala I have placed. And then government of Andhra Pradesh and others versus
Andhra Pradesh is also a reiteration of the same principle by and large.
yes. Go to para. Andhra Pradesh ಮೇಲೆ para 11.
Speaking on the jurisdiction of the tribunal.
That is para 11 man. In Andhra Pradesh case. By now, state of Andhra Pradesh and others versus Muhammad Nasrullah.
That is on 226.
That is, it was quoted in the Kolaka Chakra case. Yes. Thereafter, Samar Bahadur Singh.
Samar Bahadur Singh.
Next.
कितने paragraph?
Samar Bahadur Singh. Paragraph 11. Paragraph 11. Internal page 3. Acquittal in the criminal case shall have no bearing or relevance to the facts of the departmental proceeding as the standard of proof in both the cases are totally different. In criminal case, the prosecution has to prove criminal case beyond reasonable doubt, whereas in a departmental proceeding, the department has to prove only preponderance of probability. In the present case, we find that the department has been able to prove the case on standard of preponderance of probability. Therefore, the submission of the counsel appearing or the appellant are found to be without any merit, and the appeal accordingly dismissed, my lord. Lastly, thereafter, my lord, Damo Panna Sagar Rural Bank of India and another
paragraph
versus
paragraph
In that
What
case,
paragraph
you highlight on paragraph 18 only.
What?
Paragraph 18 of the judgment. So the question of proportionality of the
Yes, sir.
punishment is very important here too. Even if it is admitted that your disciplinary action is proper, is the order of punishment is proportional misconduct. 100% pension you are withdrawing, all gratuity entirely. The person has worked, he has served.
Yes, that is.
What that witness has stated in the disciplinary proceeding?
Yes, sir. I have questioned that.
Decoy,
Yes.
because he has not supported the prosecution case
No,
in the
no.
criminal trial.
No, at page cross examination 151 of the brief.
151 number.
Yes, sir. Question number.
Wait.
It
151.
starts, madam. 151 cross examination by the defense. He has cross
Chief कौन कोई है कौन तो prosecution?
हाँ. There are it starts 151.
151 दा.
हाँ आरंभ से. था पर पेज रे 27 question. 152.
150 এটা কাহার এভিডেন্স প্লেস করছো ডিকয়ের
মানে during disciplinary proceeding.
হ্যাঁ সেই
Yes. He has put the questions to the witness. The
deposition of PW1, that is Uday Singh
yes.
medical safai wala.
The person from whom the gratification was taken.
Yes. Uday Singh.
He is the primary. He is decoy.
Page 152. Question number.
नहीं ये चीफ को सुना दी
Chief
अरे एग्जामिनेशन में चीफ को that is page number 149.
Yes, 149. The deposition of PW1. I had visited
Gondamunda. Behind him is Gondamunda.
Gondamunda during the period February 2008 to visit my nephew. I fell sick and reported to Gondamunda Railway Hospital. I had gone for medicine and I asked for money.
I was asked.
I was asked for money. Then my nephew gave me money and sent me to the hospital. I paid the money and went out. I don't want to say anything more. First question. When you went to the Gondamunda Railway Hospital, what was the first thing you did? My nephew prepared ticket on my behalf. Where is your nephew employed? My nephew is employed in railway and at Jabaghat. After obtaining the ticket, prescription memo, to which doctor chamber did you visit? Answer. After obtaining ticket, I had gone to the chamber of Dr. Behra.
मैंने बेहरा वाले जो opposite party
Yes, ma'am. Surendranath. Fourth, please state in brief what transpired in Dr. S.N. Behra's chamber.
Yeah.
When I was gone to the chamber of Dr. Behra, the doctor asked me for money and my nephew paid the money. What was amount demanded by the doctor? Dr. Behra demanded is 1,000. Did your nephew pay the money instantly in the chamber of Dr. S.N. Behra? Yes, my nephew instantly paid the money to Dr. Behra in his chamber. When the doctor demanded for gratification, did you inquire why he was demanding for the same? Yes, Dr. Behra demanded money for medicine. Did Dr. S.N. Behra write any slip or prescription or gave medicine direct to you? Dr. S.N. Behra gave in writing for medicine and I obtained the medicine from the hospital. Do you remember what complaint you had lodged with the CBI Raulkela? Because the doctor was asking for money to give medicine, I lodged the complaint to the CBI. What did the CBI people tell you then? I went to CBI and complained that the doctor, that is Dr. Behra, taking money. CBI told if he is taking money, you will go with you. They went to Dr. Behra with me. I paid money to Dr. Behra and doctor gave me medicine. I went away. CBI went inside. Did the CBI team go with you on the same day on which you lodged the complaint? That is Saturday? Yes, on the same Saturday. Where did you take CBI team? To doctor's chamber or to his residence? I went to the chamber of Dr. Behra accompanied by CBI. When you went to the doctor's chamber for the second time, who was there with you? I was alone. State what happened when you entered the doctor's chamber for the second time. I had taken medicine from the doctor and gave the money to him. Please recollect properly and state when did you give the money and obtain the medicine from the doctor. On that Saturday at 5 p.m. evening. 5 evening. Did you meet the CBI team on the next day? That is 24/2/2008. Yes, I met. What happened on that day? I came away after entering of the CBI team into the chamber of Dr. Behra. Thereafter, examination in chief is over. Cross-examination by defense. How could you go to Gondamunda on 23/2/2008, leaving your headquarters at Adityapuर? Note, the PO submitted that this question doesn't have Behra. Who has sent you to Dr. Behra? Have you got any proof in that respect? Nobody else sent me. I had gone myself to Dr. Behra. What had you told to Dr. Behra and where he was then? I had to his office where he sits and he examined me and gave me medicine. The prescription memo you got from the registration room as a proof of your being railway servant, had you produced it before Dr. Behra? Yes, the prescription memo I had given to the Dr. Behra. Had Dr. Behra written anything on that prescription memo? Yes, he wrote something on the prescription. How many papers, after being written by Dr. Behra and returned to you for medicine, prescription memo paper was written and returned to me? 27. Did you receive medicine with the help of prescription memo? You took medicine from the hospital? Yes, with the help of the same medicine memo, I received medicine from the hospital. Please see, here is the prescription photostat copy. Show me where is the writing of Dr. Behra and his signature. Dr. Behra wrote medicine on the overleaf of the prescription memo and signed. Please see, the overleaf of the prescription memo is completely blank and nothing has have been written. You submit that the prescription memo was a xerox copy. Yes, it is completely blank. You had gone on 10:30 hours to
Bandamunda Hospital.
Gondamunda Hospital. That was 23/2/2008. Is it not true? Yes, it is correct. What you told that you had paid money on the above mentioned day, 23/2/2008. Is it correct? Yes, on that day I had given money. I think Dr. Behra was a good doctor for which you prefer to go to him for treatment, leaving other two outdoor doctors in the front. Is it correct? Yes, it is correct. Dr. Behra was not looking after outdoor patients. He was attached to indoor patients and looking after the indoor patients only. And you are an outdoor patient. Now, what you have told appears to be not true. No, I am not telling lie. You did not visit
Bandamunda on
on 22/2/2008. The complainant in the initial stage has stated that he is not clear about the date on which he has visited Bondamunda to the few summits. I did not visit on Bondamunda Hospital on 22/2/2008 on Friday. He has declared. He has stated that he had not gone on 22. Had you gone only once to the Bondamunda Hospital?
I went twice.
I went twice. First time at 10 hours and second time
17
at
hours.
5 hours.
Hmm.
You have given in writing that you had gone to your sister's house at Raurkela. Is it a fact? Yes, it is a fact. What is the name of your brother-in-law? Budhan Singh is the name. You had given in writing that you had gone to your sister's house from Adityapur. Today you are telling that you are gone to your nephew's house at Banda. And again you are telling that Bidhan Singh is your brother-in-law. Where you had given in writing that Bidhan Singh is your nephew, which one of the correct. Budhan Singh is nephew. You had gone to Raulkela where one railway doctor is there. Why didn't you approach him for treatment? My nephew Budhan Singh had taken me to
Bandamunda
instead of Raulkela. You have you have given money to Dr. Behera in his chamber at 10 hours on 23/2/2008. Could you please say why didn't you go to CBI on 24/2/2008 at Raulkela at 5 hours? My nephew had taken me to CBI. You did not have any complaint against Dr. Behera, but for Budhan Singh, your nephew lodged complaint with CBI at Raulkela on 24/2/2008 at 5 hours. On Saturday, I was taken to CBI by Budhan Singh at Raulkela at 5 hours. Who paid the money? Budhan Singh paid the money. Doctor asked you money at 10 hours on 23/2/2008 and you paid the money and took the medicine. Yes, for both the questions. 31. Yes, Mr. Udaya, tell me you are a railway employee. Railway is giving free medicine to every railway employee. Dr. Behera asked you for money for medicine. Why did you not go to some other doctor for medicine in the same complex for same complaint? Because my nephew told me to go to Dr. Behera. Is it not a fact that you have been at Monamunda to identify Dr. Behera, his place of work, his house or residence prior to 23/2/2008? Yes, I came with the help of my nephew prior to 23/2/2008. It is not the fact that you had come to Monamunda prior to 23/2/2008 with some of your medical staff presently working at Adityapur and previously working at Monamunda. No, you are sitting in the veranda of OBC office in front of my quarter some other day prior to 23/2/2008 Saturday. No. How many times you have gone to CBI in the whole year of 2008? I had gone. Was your nephew with you at the CBI office and paid money of rupees 1,000? Yes, my nephew was with me and paid me 1,000. Who others were there? I don't know the name of the persons, but 4 men were there. What was the day and what
They
do
do
with you? That was Saturday. They talked to my nephew and then they asked me whether money is there. I told yes and I gave them. What more they asked to you? No. Then what happened there? Thereafter, then CBI came behind me. You want to say whether, you want to say whatever is done, it is done on the persuasion of your nephew, Budhan Singh, and you had not taken any leading part. Is it true? Yes. The regular hearing at the stage we continued on 2010 at the scheduled time and venue. Thereafter, 5. You have told that On 23/2/2008 at 10 a.m., you got medicine prescribed by Dr. S.N. Behera from medical store and gone home. What are the reasons for reporting to CBI? At the time of taking medicine 10 a.m., I had neither paid any money nor Dr. Behera demanded any money. I am asking you, you honestly tell, did I ask you money? Matter the opposite party asked the question. Tell, did I ask you money? Did you pay me money? Question put by Dr. Behera. Yes, this is important. At this stage, Dr. Behera wanted this part of the proceeding, that is the question put by him and the reply given by PW1 expunged from the proceeding. To did not agree. This is important. Many signatures of your side I find in CBI document. Could you please say for what purpose they have taken your signature and whether the contents were explained to you? I don't know the contents, nor anybody explained me what was written there. Those signatures on documents, at what places you gave and what date? I gave all signatures in CBI office at Raulkela and no other place. I don't remember the date, but it was Saturday. 59. Yesterday, you told that your nephew took you to your office at 15 hours on 23/2/2008. Four people were there. You want to say your nephew, CBI Constable Sri Polai, Inspector Sri Kabi, and yourself. Is it true? Yes. When you returned from CBI office to Jabaghat on 23/2/2008 evening, your nephew carried you. Is it not a fact? Yes, I had gone with my nephew. I think your nephew Budhan Singh had constructed a house at Jabaghat. You were there with your nephew the whole night at Jabaghat. Is it true? Yes. You did not go to anywhere on that day or on the next day. Is it true? No, I had not gone. Isn't a fact? One of the CBI officer of Raulkela visited Jabaghat, put some paper where your endorsement, you endorse your signature. No. Uday Singh, please see this document FIR written in Hindi. You are giving your signature in the second page. Would you please say who has written it and do you know the contents? It might have been written by CBI PW1 at this stage, stated that it was written by CBI and I had put my signature. The contents were not read out and explained to me. Please see these 4 pages written in English and typed pre-tab memorandum. At the bottom of all the 4 pages, you have endorsed your signature with date. Do you know what written in these 4 pages and had anybody explained you in Hindi the contents of that document? I don't know what is written inside the document, nor anybody had explained me about the contents of that document. You please see another document written in English on hand on carbon process post draft memorandum containing 7 pages, and on bottom of each pages you have given your signature. Do you know what is written there, or had anybody explained the contents of that document? I don't know what is written, nor anybody had explained me about the contents of the documents carries. Re-examination by you. For how long had you been staying with your nephew before you fell sick on Saturday, that is 23/2/2008? I reached my nephew's house one day before, that is on Friday. What is the address of your nephew? He stays at Jabaghat. From your nephew's residence, which place is easier to reach? Bondamal.
Bandamunda Railway
Bandamunda.
Hospital or the Railway Health Unit of Raurkela.
Or the Railway Health Unit at Raulkela or Diesel Health Unit at
Diesel Colony.
it is convenient to come to
Mandamunda Railway Hospital.
railway hospital. How did you reach the railway hospital at
Mandamunda from residence of your nephew. I came by auto.
Mandamunda from the residence of your nephew? I observed that this question doesn't bearing with the main issue. At what time did you start from the residence of your nephew for the hospital? I left at 9:30 am. What is the approx time you reach at Mandamunda Railway Hospital from the residence of your nephew? It takes about half an hour. When you went to Dr. Behera for the first time, he checked you and gave you medicine, yes or no? He checked and gave me medicine. Did you from where did he give the medicine? I had taken medicine from hospital. In other words, with the help of the medicine memo given by Dr. Behera, you obtained the medicine from the hospital, yes or no? Yes. Did the railway dispensary people return back you the medicine memo against which they had issued medicine to you? The dispensary people kept the prescription memo with them. You have said that the doctor demanded 1,000 for giving you medicine, yes or no? Yes. How did you feel when the demand for money was made by the doctor from you? I did not feel anything. Just now you said that you did not feel anything when the doctor asked for the money. Then why did you go to the CBI office? I told my nephew that the doctor had demanded me 1,000 for the medicine. On this, my nephew said that okay, I will be arranging for the money. Money, you come with me, and he took me where I don't know whether it is CBI or anything. When your nephew took you to the place, did you ask him what place was that? No, I did not ask. On your request, your nephew called for one person to write a complaint against the doctor. Is it true or not? Yes, it is true. The defense asked if any outsider is written the complaint, had he given his signature that he had written it, or do you know him or his name? PW1 stated that he doesn't know the name of the person of the writer of the complaint, nor had he given an endorsement towards his name and address. Is it not true that the complaint was laid to you and after understanding you signed the complaint? The defense point out that the answer to the question is already there by the answer
To question number 64.
How long were you there in the hospital? I stayed there for about 1 hour. At about what time did you start in the hospital to go to CBI office? We left about 11 a.m. When did you lodge the complaint with the CBI? Before paying 1,000 to the doctor or afterwards? The objection of the defense is that the PW1 has not lodged any complaint to the CBI and question of the Honorable PO appears to be leading. I gave the money after lodging complaint to the CBI. The defense objected to the answer given by PW1 in respect of the contents. How long did it take you to reach CBI office from the hospital? About half an hour. The defense objected the reply on the ground. Medicine from the hospital 10 am and on 23/2/2008, the PW had gone to Jabaghat, in a few hours. After the complaint was written, it was you who had lodged the complaint with CBI Inspector C.D.K. Kabi, yes or no? The defense objected this question for PW1 had already stated earlier that he was not knowing whether the complaint was lodged with CBI. Yes, he has answered yes. When you lodged a complaint with Kabi, he asked you to the next day? Yes or no? No. Then what did he tell you? Please say. He did not tell anything. You had stated that you had been asked by the CBI whether you had rupees 1000 required for payment on previous occasion. On this, you had stated yes. Now, how is that you are saying you are not told anything by CCOB? The CBI only asked, is money is there? I said yes. How long were you there in the CBI office? I stayed till 4:30 p.m. What happened after 4:30 p.m.? Please explain. After 4:30 p.m. I came to Bandamuni. Just before you had been shown first by the Honorable Defense Helper, which contained your signature. Was this paper signed before leaving the hospital or after? The defense objected to this question as it has no relevance with the main statement obtained by the PO. The re-examination by PO is over. PO observes since the whole event has been seen in detail from various angles, the prosecution and defense are unanimous not in further examination or re-examination of PW1. Thereafter,
No, so what it transpires, we have gone through is this complainant has supported its case during this
yes,
disciplinary proceeding when he was examined as PW1. And have you gone through the evidence of this witness in the criminal trial? He has also supported the prosecution case. But why the acquittal order was passed, the reason is that prescription.
Yes, sir.
You come to the question number 24, this which you are just placing. Question number 24 to 29.
Yes, sir.
So से प्रेस्क्रिप्शन टा तांकर आनिला परे से जो डॉक्टर को देखिबा कथा देखान राइट
Yes, sir.
से ताको पचार देई गले क्वेश्चन जे तापण प्रेस्क्रिप्शन आनिले ना हो आनिलु से प्रेस्क्रिप्शन टा कोन कले ना मु आनिकिनी डॉक्टर बेहरा को देखैली डॉक्टर बेहरा कोन कले ना से प्रेस्क्रिप्शन ने किछि लेखिले मेडिसिन लेखिले तापर परवर्ती प्रश्न हला एई प्रेस्क्रिप्शन आपन को लेखिले ता को यूटिलाइज करी आपण किछि मेडिसिन किनले कि ना हां मेडिसिन किनिलु एवं मेडिसिन मजे पाइलु अच्छा तापर से फोटोकॉपीटा देखैले प्रेस्क्रिप्शन क्वेश्चन नंबर 28
Yes.
से तांको पचारचंदी द क्वेश्चन यू सी दिस प्रेस्क्रिप्शन एंड शो मी वेयर इज द राइटिंग ऑफ डॉक्टर बेहरा एंड हिज सिग्नेचर
On the flip side also, which was
says the Dr. Behra wrote the medicine on the overleaf of the prescription memo and signed. Next question, please see the overleaf of the prescription memo. It is completely blank and nothing has been written. Say कहले जे yes, it is completely blank. है ना? Say जोटा xerox copy करे.
Yes, sir.
Same thing in the trial court that was proved, that is exhibit 5. If you see the judgment of the trial court, exhibit 5 and the analysis of the trial court, जे आर केस होची मेडिसिन लेखिवा पाई डिमांड करथला 1000 टका हला 1000 टका नेला तापरे मेडिसिन लेखिला किंतु टा जेहेतु प्रमाण करूचनी प्रोसिक्यूशन ता देरे कोनोसी राइटिंग नाही डॉक्टर बेहरांकर तार सिग्नेचर नाही तेणु डॉक्टर बेहरा आपाई मेडिसिन लेखिथिले एवं से मेडिसिन पाई 1000 टका डिमांड करथिले एटा एक्सेप्टेबल नुहे that was the main ground of acquittal. That trial court judgment. Come to that.
Yes.
You'll see that same thing he has stated. Court judgment achi apanଙ୍କର page. You come, that is the page number. It is the ketoda page number diaichi. We do not know, perhaps It is
color
हाँ 226 से आरंभ हुई ये जो 226 को पढ़े सुन स्पेशल जो सीबीआई भुवनेश्वर टीआर केस नंबर 100 है ना फाइल से पे इसको नाउ यू कम टू prosecution case छाड़ दियो you come to the evidence of this decoy and that is there in paragraph 8 question paragraph 8 answer recording মানে discussion age please page that is page number 237 maybe 237 or
fact remains that.
fact remains that. Please read it.
Page 131.
131 not 231.
Sorry. Fact remains that in a case of this nature, the most important witness is none other than the complainant. This complainant Uday Singh Sawan, appearing as PW5, has deposed that on 23/2/2008, he had been to the house of his nephew Udhan Singh Sawan at Bondamunda, where his nephew was working as sweeper in Jabaghat pump house of the Southeastern Railway. According to PW5, he suddenly fell ill, for which he was taken to Bondamunda Southeastern Railway Hospital, as he was entitled to be treated as an employee in that hospital. The registration for his treatment in the hospital has been marked as Exhibit 5. The complainant has specifically alleged in his evidence that he met Dr. Surendranath Behera with his registration ticket, but he told him to treat him well in his residence located near the hospital and demanded 1,000. The complainant has also deposed when he went to the residence of the accused. He asked for the money, after which he handed over tinted government currency notes to the accused in his right hand. His further evidence is that the accused kept the tinted government currency notes in the pocket of a coat which was lying on the sofa. His evidence further discloses that the accused asked him to come to his house on the next day for collecting medicine. He specially testified that he came out of the room and gave signal by combing his head with the hands. Defense cross-examination has brought out the damaging admission in the cross-examination of the complainant. He has admitted another person was present in the room of the accused when I entered into the room of his house. It is not a fact that the accused doctor refused to treat me in his residence. It is not a fact that when I insisted for my treatment, the accused doctor treated me in his residence. It is a fact that the accused doctor had refused to accept money from me towards his fees.
It is a fact that.
It's not a fact that. It has been materially elicited in the cross-examination of the complainant that when they had gone to the CBI office, his friend entered the chamber of the inspector and he was asked to remain outside of the office room. His further admission is that his nephew and his friend remained in the chamber for half an hour, after which he was asked to sign on a paper. He has candidly admitted, I don't know the contents of the FIR, but I have signed on it. My nephew told me to come to CBI office on the next day evening. The trap-laying officer, C.D.K. Kabri, appearing as PW9, has deposed that the complainant has no knowledge about the contents of Exhibit 9. What cannot be lost sight of the OPD ticket contained in Exhibit 5, which clearly shows that neither it bears the name of the patient the nature of disease nor reference to indoor doctor as indoor patient. It is therefore more than apparent that the scope, opportunity, a question of meeting the accused in the indoor and checking of the health in the indoor doesn't arise. The prosecution has signally failed to produce and prove a single document or OP ticket in support of the assertion that the complainant was checked as
এইটা হଉଛି
the
ମେନ୍
outdoor
ଏଇଟା ହଉଛି
patient.
ମେନ୍ ଡିଜିଜ। କାରଣ ଆପଣଙ୍କର କେସ୍ ହଉଛି କଣ, ଯେତେବେଳେ ସେ ଯୋଉ ପ୍ରେସକ୍ରିପସନ ଟା ଆପଣ ଆଣିଲେ ସେଟା ରେଜିଷ୍ଟର କରି ଆଣିଲେ, ତାପରେ ଡାକ୍ତର କଣ କଲେ ନା ଡାକ୍ତର ଟଙ୍କା ଡିମାଣ୍ଡ କଲେ, ଟଙ୍କା ଯୋଉ ଲେଖିଲେ ପ୍ରେସକ୍ରିପସନ, ଏବଂ ସେ ପ୍ରେସକ୍ରିପସନ ଟାକୁ ୟୁଟିଲାଇଜ କରି ଆପଣ ମଧ୍ୟ ମେଡିସିନ କିଣିଲେ, ଯୋଉଟା କି ଆପଣ ଦେଖିଲେ ପଢିଲା ଭଳିଆ। ବର୍ତ୍ତମାନ ଏଇ ଯୋଉ ପ୍ରେସକ୍ରିପସନ ଟା ପ୍ରମାଣ ହେଲା, ତା ଦେହରେ ନା ଡାକ୍ତର ବାବୁଙ୍କର କିଛି ଲେଖା ଅଛି ନା ସିଗ୍ନେଚର ଅଛି, ତେଣୁ ଫାଇଣ୍ଡିଂ ଆସିଲା ଯେ କୌଣସି ଡକୁମେଣ୍ଟ ପ୍ରସିକ୍ୟୁସନ ପ୍ରମାଣ କରେଇନି ଯେ ଡାକ୍ତର ବାବୁ ଟଙ୍କା ନେଇକିନି କୌଣସି ମେଡିସିନ ପ୍ରେସକ୍ରାଇବ କଲେ ବା ତାଙ୍କର କିଛି ଲେଖା ଥିଲା ବୋଲି। ସେ ଡକୁମେଣ୍ଟଟା ଗୋଟେ ବ୍ଲାଙ୍କ ଡକୁମେଣ୍ଟ। ଏଇଆ ହଉଛି ତାଙ୍କର।
No, that is right. He has been acquitted. So, the question is, my at that before passing of the judgment, acquittal judgment, already this kind of proceeding has been
completed even.
Awarded punishment. Thereafter, 1 month, the acquittal has been passed. So, had the disciplinary proceeding been stayed in the continuance, then it could have been held him. So, acquittal, on the basis of acquittal, punishment will be awarded. But there is no scope for the disciplinary authority to take the conviction acquittal judgment into consideration. Say basis and the London Tribunal has also dealt vividly in the previous judgment. If your lordship can have a glance to that judgment, he has already taken all the grounds. An opportunity was given. He has never denied any violation of his nothing is there, madam. But as this honorable court remitted back the matter, and that was not on merit matter. Only this honorable court finds that as the rule has not been complied with, the judgment has not been pronounced within the stipulated period, so the matter has been remitted back for hearing without adducing any fresh document. That is also written in that judgment also. No new evidence will be adduced by the parties on available the documents which are available in the that should be taken into consideration. And on reappraisal of evidence, the tribunal has held that the opinion of the UPSC has not been given, but that was given. But at the time of supply final order, along with the opinion has been given, and that was not in the way the applicant has never pleaded with regard to that aspect. That is never his case. But the tribunal reversed on that ground only. And which issue is my can have a glance to Annexure 6 series. I have annexed the 6. 6 is minus 389, page 389. Six is 389 page. On this issue, there are batch of matters are subject before the Honorable Apex Court regarding supply of advice of UPS. That issue is pending before the Apex Court, and I have also wherein interim orders have been passed, and I have annexed that orders also, madam. She super privilege, but the relying on such issue where the tribunal has stated that the advice was not handed over, so it is a violation of justice.
So on that ground alone, it has not been.
It is one of the grounds.
Yes.
And well, so far as the national justice witnesses were not given opportunity to examine or documents, well, even if a delinquent officer asks each and every document, if they are not relevant, that should not be, that is not mandatory to provide that matter. First thing. Second thing, so far as examination of witness is concerned, well, he has participated throughout. Well, I have announced all the witnesses which he vividly participated in the proceeding. He has examined, cross-examined, all opportunity has been given. Sufficient opportunity has been given to him. That is there.
So
What the learning?
whatever the punishment part which has been
that is your lordship's consideration.
Huh?
That is lordship's consideration.
No, that is what is very important here.
Yes,
all right, ବର୍ତ୍ତମାନ ତ ବୟସ ହେଲାଣି ଆପଣ
that is admitted, man.
100% pension, gratuity. And the question was also a matter. It's a matter of principle, though gratification is not expected from the doctor. But having seen the various infirmities in all the cases, and finally the acquittal in departmental cases also there is infirmity. Though it is from the side of the defense that he has brought on record. That has he taken? Yes, he said yes, it is taken. Otherwise, things would have been different. So because the disciplinary authority will not go strictly in the evidence, so they have found him guilty. And truly, that order came later. The acquittal order has come later, but the proportionality of the punishment. Apparently, do you have any decision out of this? It shows that it is proportionate.
ଆଉ ଦିଟା decision I will provide to you election. ଗୋଟେ ହଉଛି whether what my lord queried of disciplinary proceeding, thereafter acquittal order. So with regard to that, I will also research and give.
That you give, but the fact that is already settled. That accepting.
Decision about the punishment part.
Yes.
Which has been
Disproportionate punishment.
That is very important here.
I will provide. The settled position disciplinary authority.
We'll hear the other side,
Yes.
and we can take up this matter for some time on Tuesday so that it can be finally concluded.
Last week, reopening of
No. I'm what do you think about?
My humble submission.
11
may not require that clarification. That's my humble submission. I'll endeavor to show that I'll try and satisfy your lordship's query that if there is a judgment which says that disciplinary proceeding award was passed, then subsequently a criminal case came in, and what would happen there? There is a judgment of the Honorable Supreme Court passed this year in February. I'll just pass the order.
Ramnal.
A small note in the judgment. I'm also giving a copy to you. If you sees that judgment, I'll directly come to the judgment.
Ramnal. So the effect of acquittal I have also seen in
MOT.
Yes.
My lord, may have this judgment, my lord. As your lordship said, my lord, I'll start with the facts itself. My lord, may kindly have para 4. Para 4 of the judgment, my lord.
Yes.
Para 4 of the judgment. My lord, I'll come to the note, my lord, later. My lord, para 4, may I state, my lord?
Yes.
My lord, 5 witnesses were examined in the department proceeding. These very 5 witnesses were also examined in the criminal trial. Apart from 8 other witnesses who were also examined at the criminal trial, The inquiry officer in the departmental proceeding found the charges proved in the disciplinary authority by an order of 31/3. Kindly note the date. 31/3/2004 dismissed the appellant from service. The appellate authority also dismissed the appeal. Attempts to have the order reviewed and penalty reconsidered were also in vain. At the criminal trial, the trial court convicted the appellant for the offence under section 420 and sentenced him to undergo 3 years imprisonment along with a fine of rupees 5,000. The appellant. The appellant thereafter represented for his reinstatement. Not a review, but it represented for his reinstatement. Subsequently filed a writ petition in August 2008 for quashing the dismissal order dated 31/3/2004, the order of the appellate authority, and the orders refusing the review and reconsider the aforesaid orders. The learned single judge, by his judgment dated 31/3/2008, dismissed the writ petition by holding that the standard of proof in a criminal proceeding and proceeding is different. The learned single judge found no infirmity in the order of the disciplinary authority. The writ appeal filed by the appellant has also been dismissed by reiterating the findings of the learned single judge and by further elucidating as to how the parameters of a judicial review against an order in a departmental proceeding are limited and circumscribed. Being aggrieved, the appellant is an appeal before us. Question for consideration. The following two questions arises for consideration. 8.1a. Whether the dismissal of the appellant from service pursuant to the departmental inquiry was justified. B. On the facts of the case, what is the effect of the acquittal ordered by the appellate judge in the criminal trial on the order of dismissal passed in the departmental inquiry? We have heard Mr. Sohel, and let me state the legal position. Para 10. We have examined both the question independently. We are conscious of the fact that a writ court's power to review the order of the disciplinary authority is very limited. The scope of inquiry is only to examine whether the decision-making process is legitimate. As part of that exercise, the courts exercising power of judicial review are entitled to consider whether the findings of the disciplinary authority have ignored material evidence, and if it is so finds, the courts are not powerless to interfere. We are also conscious of the fact that mere acquittal by a criminal court will not confer on the employee a right to claim any benefit, including reinstatement. However, if the charges in the departmental inquiry and the criminal courts are identical or similar, and if the evidence, witnesses, and circumstances are one and the same, then the matter acquires a different dimension. If the court in judicial review concludes that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge, the court in judicial review can grant redress in certain circumstances. The court will be entitled to exercise its discretion and grant relief if it concludes that allowing the findings in the disciplinary proceeding to stand will be unjust, unfair, and oppressive. And my lord, they have quoted each case will turn on its own fact. My lord, they have referred to GM Tank, which is also referred to the lower court, my lord, and also Samuthiran, which was quoted him Singh case, my lord. Now, if your lordships, if your lordship wants, I'll place para 28, my lord, because that's relevant. 28, my lord. Internal page 183, para 28.
No, effect of acquittal in so and so question number 2, para 25.
Well, 25 I can start from.
Yes.
Yes. With this above background, if we examine the criminal proceeding, the following factual position emerges. The very same witnesses who were examined in the departmental inquiry were examined in the criminal trial. Jagdish Chandra, Bhavani Singh, Talal Raj Singh, and Karan Sharma were examined as PW so-and-so, respectively at the criminal trial. Apart from them, 8 other witnesses were also examined. The gravamen of the charge in the criminal case was that the appellant had submitted an application for recruitment along with his mark sheet, and he, by making alteration in his date of birth to reflect the same as this, in place of this, and obtained recruitment to the post of constable. Though the trial court convicted the appellant under section 420 IPC, the appellate court recorded the following crucial. The court recorded the following crucial findings while acquitting the appellant. Mainly the present case was based on the documents to this effect. Whether the date of birth of accused is this or that. Exhibit P3 is original mark sheet in which the date of birth of accused has been shown as 21/4/1972, and the same has also been proved by witnesses examined on behalf of the prosecution. Whatever the documents have been produced before the court regarding the date of birth of 21/4/1974 are either letter principal or are duplicate TC or mark sheets. Neither the prosecution has produced any such original documents in the subordinate court to this effect that when the admission form of accused was filed, that what date of birth was mentioned by the accused in it, what was the date of birth and roll register of school, what date of birth was mentioned by accused in the examination form of secondary, and nor after bringing the original records from the witnesses concerned, same were got proved in the evidence. In these circumstances, this fact becomes doubtful. The date of birth of the accused was 21/4/1974, and the accused is entitled to receive its benefit. In the considered opinion of this court, the conviction made by the subordinate court merely on the basis of oral evidence and letters or duplicate documents is not just and proper. It is justifiable to acquit the accused. Resultantly, on the basis of aforesaid consideration, the present appeal filed by the appellant accused is liable to be allowed. What is important to notice is that appellate judge has clearly recorded that in the document exhibit P3, original mark sheet of the 8th standard, the date of birth was clearly shown as 21/4/1972, and the other documents produced by the prosecution were either letters or duplicate mark sheet. No doubt, the appellate judge says that it will become doubtful whether date of birth was this and that accused was entitled to receive its benefit. However, what we are supposed to see is the substance of the judgment. A reading of the entire judgment clearly indicates that the appellant was acquitted after full consideration of the prosecution evidence and after noticing that the prosecution has miserably failed to prove the charge. Expressions like benefit of doubt and honorably acquitted judgments are not to be understood as magic incantations. A court of law will not be carried away by mere use of such terminology. In the present case, the appellate judge has recorded that Exhibit P3, the original mark sheet, carries the date of birth as 21/4/1972, and the same has also been proved by the witnesses examined on behalf of the prosecution. The conclusion that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge can only be arrived at after a reading of the judgment in its entirety. The court in judicial review, Melod, has it been?
Yes.
Melod, yes. I'm sorry. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of expression used. We are satisfied that the findings of the appellate judge in the criminal case clearly indicate that the charge against the appellant was not just not proved. In fact, the charge even stood disproved the very prosecution evidence. As held by this court, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. A fact is said to be not proved when it is either proved nor disproved. We are additionally satisfied that in the teeth of the findings of the appellate judge, the disciplinary proceeding and orders passed thereon cannot be allowed to stand. These charges were not similar but identical, and the evidence, witnesses, and circumstances were all the same. This is a case where, in exercise of our discretion, we quash the orders of the disciplinary authority and the appellate authority, as allowing them to stand will be unjust, unfair, and oppressive. This case is very similar to the situation that arose in GM Tank. Apart from that, then it continued.
Ultimately, what was held?
Ultimately, accordingly, we set aside the judgment of DB Para 34, DB Special Appeal, We direct the appellant shall be reinstated with all consequential benefit, para 34, including seniority, notional promotion, fitment of salary, and all other benefits. As far as back wages are concerned, we are inclined to award the appellant 50% of the back wages. The direction be complied with within a period of 4 weeks from today.
All those decisions which have been placed by the Land Council
have all been discussed here.
No, Ramlal and Tank has been.
No, this is the Ramlal.
But yes, this is Ramlal. Tank is there.
My lord, Tank is also there. My lord, my learned, my lord remembers, my lord, my colleague referred to him saying, where my lord Samuthiran was 24, 25.
Tamil Nadu.
Samuthiran was also there. Ramlal was not. My lord, because Ramlal came this year and those judgments were of last 2 years. Now, my lord, apart from this, there are, if I name this, now, my lord, my reading of the lower court, the impugned order is on 3 grounds. The impugned order, when it was remanded back, the lower court allowed my case. One is because you were honorably acquitted by the lower court. Point number A. Point number B, that there has been violation of principle of natural justice. Now, 3 is CVC report. These are the 3 grounds on which. Now, my lord, my learned colleague now says that CVC report issue is pending before the Supreme Court. Now, my lord, even if I argue against myself that I will not get the benefit of CVC report, the other two, I'll only say, my lord, on the first ground that it has been the CBI case, my lord, in that criminal case, it as this judgment said, my lord, they have not used the word acquitted, but it says if it has been acquitted after examining all the evidences. Now, my lord, one critical, your lordship has already gone through it. That makes my job much more easier. My lord, one fact which has probably not been brought to your lordship, there's 2 glaring inconsistencies both in the DP and in the criminal case. My lord, I'll show my lord to the proper case. My lord saw the chief examination. Now, my lord, in the examination in chief, he says that I went. Now, my lord, first glaring possibility, he says he's an outdoor patient. It is accepted he's an outdoor patient. It is also a fact, my lord, on that particular day, I was not the outdoor doctor. I was the indoor doctor. One of the reasons why I have been allowed that, yes, principle of natural justice has been violated is because, my lord, I kept on asking for documents to prove that I was indoor. I could not have met him. That is why, my lord, specific cases have been put in and they have said categorically, my lord, if I may say, my lord, kindly have page 150, my lord.
Another thing,
yes, sir. Yes, sir.
Suppose in that criminal case,
yes, sir.
You are required to prove, to establish such a charge. You are required to prove 3 aspects. What are those 3 aspects? Demand, acceptance, and recovery. So let us say that that witness has stated something, but the trial court disbelieved it on the ground that that very document on the basis of which it is stated that the demand was made, that is totally blank, that is Exhibit 5. But fact remains that it was recovered, that tainted money was recovered from your possession, right? So how that tainted money came to your possession?
On that aspect of recovery, I probably have my hands
because that was requirement for establishing that charge.
I completely.
So far as disciplinary proceeding is concerned, since the standard is different, it is not required to prove all the 3 ingredients before the disciplinary authority. So disciplinary authority, if that money has been recovered from you and you are the disciplinary authority is not convinced with the explanation which you are offering. What explanation you are offering in fact?
Just 2 things. Recovery in today before your lordships, I must as an officer of the court state candidly, clearly, I have my hands tied. I have no material to show how can I argue about recovery. There are 2 things. If the possibility of meeting itself is so alien, that should raise doubt itself. Now, my lord, I'll just take your lordship to 2-3 things. As I said, number 1 is I was an indoor doctor. I was not supposed to look at outdoor. That question is put to him. He says, my nephew asked me to go there. Why did you go there? Why didn't you go to 2 doctors who are outdoor? I don't know. Somebody asked me to go there. I'll show you, lordship. That's point number 1. Now, point number 2 is, My lord, when he says, my lord, I read the entire thing, my lord, may recollect. He says, I went and asked, I went to him. He said, give me 1,000 rupees, then only I'll write that medicine. Then he says, I got the money from my nephew, gave it to him. My lord. So, his first case is, he asked me money, I write there and then I paid the money, got the medicine slip, got the medicine. I got the medicine. Now he again says, no, so if my lord, my money was taken, what was the trap case for? He says that I've given the medicine. Then he later on says,
that is how I told you that in the entire gamut of this cross-examination, it is you who has got it from the witness, saying that you asked him for money, he said yes. He said yes. Now the question arose that whether he paid it at 10 hours or at the time when the CBI took him.
Absolutely.
So those are the two things.
I'll just take your lordship. My lord, just two things. I'll just quickly take your lordship to that fact, my lord. If you had 150 again, because those are because your lordship spend a lot of time on this, my lord, the chief examination, my lord, may kindly have it, my lord.
So what we are proposing that we are, because she is also asking for time, we are keeping this matter on Tuesday. Tuesday is 1st of October 20. Okay. So
as the first one,
it will come in the supplementary here. The matter further.
And my lord, just to let you know, my lord also asks the pertinent question that is there a judgment on the fact that whether the punishment is not in
that judgment.
I have also got judgment.
Commensurate
My lord, that also I have got a judgment.
Asked him to that.
My lord, I have also got a judgment.
We are more on that because the judgment that you have shown right now in 2024 also may be taken as per incurrence because other judgments of 3-judge bench is also there, where it is again said. So it has to be seen.
I completely bought it. That is why
it has to be seen.
I'll try to make my case on both accounts. One is that I have been honorably acquitted, that is my case. And second, my lord, I'll show from the records how no principle, principle of natural justice has been violated, my lord. I'll show on those two grounds.
Okay. So it is according to 13 part for the matter to be listed on 1st of October 2022.
And on 1st of October, I'll start with.
Don't ask for time. We want to close this matter so that even
I am not
to write the judgment during the puja. Okay. So don't take time. This ground, that ground.
No, I never take time.
Be wastage of time.
Interim to continue. There is interim.
What interim order is there?
We have content proceeding.
Stage to continue.
This person is under dialysis. He's 72. So that.
No.
I completely bought him. We'll be there. I'll be there.
I kindly put to